What is the process for registering a trademark with the USPTO if there's already a similar one from another country? So this question wasn't 100% clear, but first of all, you need to know that trademarks are country specific. So if there's a registration in a foreign country, the U.S. Patent and Trademark Office, which is the USPTO, is not going to look at that foreign country. And in general, that foreign registration would have no rights in the U.S. and vice versa. However, if there is a registration owned in the U.S. but happens to be by a foreign company, the USPTO will use that to cite against your trademark. So it's going to really come down to how similar are the goods and how similar is the mark. Of course, if they're spot on, if it's the same exact trademark, the same exact type of product or service, they are going to reject it based on that. Now, something that I didn't mention in this answer is foreign trademarks owned by foreign companies, if they're based off of a foreign registration, is the one way in the US you can get a trademark registered without actually having to show that you're using it in the US. So the US is one of the few countries in the world that requires you to show how you're actually using your trademark in US commerce, and you cannot get a registration until you show that. Except if you have a foreign registration in a foreign country and that's your home country, you can then file into the US and base it off of the foreign registration. Now, if that foreign company never uses it in the US, you could potentially seek to have that canceled. So that's potentially one way to handle it. But if they are using it, it's probably going to be an issue because the USPTO is going to go through the same steps that they would with every other application. So here we have doing a comprehensive search, which is what you should do on your own before filing, so that you don't waste time and money trying to register something that is already registered, as well as this way not to use it going forward because you might be infringing on someone else's rights. But once you have a name, a brand that looks good, a logo that looks good that you think you can get, you file the application and examine it currently at about 8 months after it's filed, an examining attorney will pick it up. They might object to it or reject it. They might have just some minor objections to the way you worded something or the way you described your logo. Or they might have something more substantive objection, such as, hey, there's this prior registration here that there would be a likelihood of confusion, or this trademark is primarily merely descriptive or primarily geographically descriptive, and reject it based on those. Of course, you can respond, either by making amendments, by arguing why there would be no confusion between these or why it's not descriptive. Once you get past the examining attorney, it's published for opposition, which is when a third party, potentially that foreign owner, if for some reason the USPTO didn't cite it against you, they can come in and oppose it. Of course, if they haven't been using it in the US, they might not have, strong grounds. And then after that, you would receive either your registration if it was based on use, or your notice of allowance, which says you have 6 months to show us how you're using this in commerce. And you'd have to file over here, number 7, your statement of use showing that. Or you can, file an extension. You get some good amount of time up to that. It's a whole long procedure. I believe I have other videos that lay that out more. But if you like this, please subscribe, thumbs up, and thanks for watching.